Good afternoon, everybody. Welcome to our whistle-stop tour of Redundancy Hotspots. So I'm just going to move on and make some introductions. So you know me, I'm Joan Cradden, partner in the employment team, and Fiona Harrell up in Aberdeen, who's obviously, you don't know that she's in Aberdeen because we're all virtual, but Fiona is the partner based in Aberdeen. We're going to move very swiftly through this, as I said. The next slide just really shows you what we're going to cover and what the billing is for the session. I'm not going to go through that in detail. I'm going to jump right in and cover the first subject. But before I do that, terminology, just a very quick word on terminology. Every organization uses different language. And when we're talking, Fiona and I are going to use different terms. These are terms of art, they're not legal terms. The law relating to unfair dismissal and redundancy has been the same for a very long time. And we haven't had a lot of new case law other than in one area, which I will touch on. But the fundamental tenets are consultation, fair selection, and the exploration of reasonable alternative employment. And you will know that. And if you follow those processes, that you follow those criteria and you embed those in your process, you really ought to be able to get to fair dismissals. So when is a redundancy not redundancy? The situations you come across most often are the ones on the slide. So you've got a site closure, a geographic redundancy, you will recognize that. Straightforward headcount reduction, 10 down to 5, something like that, you recognize that. The more sophisticated area, the grayer area, and in fact now the most common form of redundancy is role redesign and restructure, where effectively what you do is you take a set of jobs and you change them. And that, of course, is almost, sometimes that just comes out of a headcount reduction, because if you reduce numbers, you have to change the jobs that people do. But as you can see, looking at the definition, where you have to meet the definition of redundancy, which is that your requirement for employees to carry out work of a particular kind has ceased or diminished. Sometimes it's hard to get those into that box. So to illustrate that in the next slide, I've given you a Venn diagram. We're going to come back to this when we're talking later on about alternative employment. But just for now, if you have a look at what the way in which we identify new jobs in a restructure that involves a diminished requirement for employees, you've got matches, and that's not a legal term, that's a term of art. Suitable alternative employment and alternative. And I've done it as a diagram, a Venn diagram, so you can see that there are no black and white lines between those three boxes. In fact, there's lots of grey in the middle. And the real redundancies will arise where you start to look at the jobs as suitable, alternative, or alternative. A match is what we tend to view as being a job which is so close to the individual's current role that they could be doing it within the terms of their existing contract or job description. And that is that, but the line between that and suitable alternative is often grey. And you're often asking us to identify which is which. And sometimes it's not that straightforward. So I want you to keep in mind the fact that this is sometimes quite fluid. Let's just talk about pooling. We're going to come back to that in a moment. Let's just talk about pure pooling. One big takeaway on pooling really is that it's your decision. It has to be rational, and there are principles on the slide that will help you determine how to pool. But the key to getting pooling right is consulting on the pool. And I think we are finding you forgetting that, particularly where you're doing it outside a collective consultation. And then if you're doing it in individual contexts, we sometimes forget that a challenge to pooling is possible. And the easiest way to defend it is to have consulted with the individual about the pool you've put them in. And it's just really a watch point. Broadly speaking, though, the criteria that you'll need to use are on the slide. When we move on then to selection criteria, this is one of our favorite areas, because this is where we're really pushing the boat. We know that selection criteria in a redundancy situation have to be objective. So things like motivational fit, attitude to work, etc., those are all far too subjective. Now, often what we see is you're taking performance criteria and you're bleeding those into redundancy selection criteria, and sometimes your performance metrics can be quite subjective. So really, you've got to try and focus on things that are objective. Coming back to the two minor points just before I come back to that, attendance records. Unless your existing agreement, if it's a collective agreement on redundancy selection, accounts for it, we're tending to say take attendance out. And last in, first out is increasingly unpopular, obviously because of the link and the bleed into sex or age discrimination. But the golden rules on selection criteria are numerical scores and words for explanation. So if you produce a matrix, get the line managers to explain the scores. That pushes them to give you an ability to show the employee individually exactly what the answer to the why me question. If you've got multiple scorers across a larger organization, grandfather it, so have a consistency checking mechanism. And finally, and I've said this, I'm going to say this repeatedly, make sure you consult with the employee and you give the employee the opportunity to challenge the scoring process. So sometimes in a collective environment, what we do is we agree all of that up front and then we run it, which is fabulous because that ticks all the boxes. But when we're in individual scenarios, we often forget to ensure that we're doing a proper selection exercise, a consultation rather, on the selection exercise itself. Just as a little list for an aid memoir of the things that can be challenging when it comes to pooling and selection, I've given you the most common complaints that we get on pooling and selection, and the one focusing in then on the why me one, that often links into a request that people see the scores that other people got. You don't have to give out all of the scores in a spreadsheet or however, whatever form it's in, but just remember that in the event that you can't explain it, you may find yourself giving some information to the individual of where they sat, for instance, relative to the scores of others, so that they can be satisfied that marginal differences won't make much change to their own circumstances. But be prepared to do the explaining, which is why I made the point earlier about words as well as numbers. And then we're going to talk about redeployment. So redeployment, I'm going to look at redeployment in two scenarios. You've got what I call ordinary redeployment, and then you've got redeployment in the context of restructuring. And in that context, the question we always ask is it selection for redundancy or selection for redeployment? And that matters because that affects the objectivity or the subjectivity of your selection system. Just briefly on ordinary redeployment, it's very straightforward. You have an obligation to consider it. That's the obligation, is to consider somebody for alternative employment. You mustn't assume that somebody won't be interested in something. So those of you who use systems which involve a widespread sharing of vacancies, etc., all of that is particularly helpful. When it comes to suitable alternative employment, and Fiona's going to talk a bit more about this, remember, it is a subjective test. So the employer and the employee's perspective matter when it comes to the identification of suitable alternative. But of course, the value in it is it can be a way of avoiding making payment of a redundancy pay. That's the reason we like to try and get that right. But Fiona's going to cover that in a bit more detail. Then finally, for me, just looking again at this question of how you handle restructures in SAE, and that point I made at the very beginning about there being a little bit of case law that's useful or interesting on this. I suppose the point, my biggest point is, the law has not matched practice, and we're running in a situation where we think we might be about to get some interesting challenges to the way in which we've come to handle redundancy selection exercises. When you look at the point is about objectivity. When you're selecting for redeployment, then you don't have to be, in law at the moment, you don't have to use objective criteria. You can be more subjective. But there is some academic commentary about that being a sort of undoing the existing case law on the requirement for objectivity. So that is a can of worms yet to be opened, and it hasn't been opened yet, but we can see it coming down the line, obviously in circumstances where we're going to get more challenges over the next year or so. You can then see how that becomes important when you start to look at things like how you handle new vacancies that are created in a restructure. Are you going to ring fence them? Are you going to give protection to the people who are potentially surplus in that environment? Are you going to let them go first? Are you going to open the vacancy to the wider team immediately? You may be under pressure from the business to do that because they want the best person for the job. Do they have to take the best person for the job? Or are you in a situation where you really should be putting somebody in just because they can effectively meet the basic criteria? So every organization will have a different way of doing that. And again, because we are in grey territory here, the big point is consultation, because talking to your people, either via a union or employee representatives or the individuals themselves, about how you're making those decisions is your way of securing fairness. Because if people don't challenge it and they fundamentally believe that it's reasonable and fair, you will have that safeguard when it comes to securing a fair dismissal. So I'm going to hand over to Fiona. No doubt there will be other questions, but Fiona's going to pick up where I left off in relation to suitable alternative employment and trial periods.
Perfect. Thank you, Joan. So quite often we find circumstances where an alternative role has been identified for an individual who's at risk of redundancy, and employers thinking about a trial period, but perhaps has forgotten or never been aware of the fact that there is a statutory 4-week trial period that will apply in certain circumstances. So this isn't a sort of optional, is it part of our process or not? The statutory 4-week trial period will apply in circumstances where an individual is offered alternative employment with different terms and conditions. So there's going to have to be an assessment as to the individual's old role and the T's and C's that apply to that as compared to the new role that is being offered to them and the T's and C's that sit alongside that. And just as I've said on the slide, all differences will count unless they are completely trivial or insignificant. Each employment term is considered individually, so it's not that situation where you take a step back and you look at it holistically and say, well, net pretty much the same, so happy to go on that basis. We are looking at each employment term individually, and it's irrelevant that the new terms may be more favourable than the old terms. So actually, in many situations, you'll be facing a statutory trial period applying, even if that's what you would have done as a matter of process anyway. And trial periods are a tricky issue. That's why we're including them in this session. If we go on to the next slide, I'll show you why. There can be lots of different outcomes, and I'm a very visual person. That's how I learn and remember. So this slide is helpful for me, and I hope it is for you too as a sort of takeaway, but I'm going to talk you through it. So if we start from the left-hand side of the slide, obviously what we're all hoping is that the outcome of the trial period is that it's successful. So the employer and the employee both agree that the individual is a good fit for the role and that they're going to continue to perform that role on a permanent basis. Thereby, there's no dismissal and there's no entitlement to a statutory redundancy payment, and we've avoided making a redundancy in that situation. So I think that's all quite clear and quite easy to follow. Next column along, we've got a situation where the employee decides that the AE, which is my shorthand for alternative employment, is not for them. So within their 4-week trial period, they think, do you know what, this is not working. In that situation, they are treated as having been dismissed for redundancy when their old job ended, so as if they had never spent any time in the trial period. But there might be a situation where they're not entitled to a redundancy payment, notwithstanding the fact that their employment is terminating by reason of redundancy. And that will be the case if the role was SAE, so if the role was suitable alternative employment, and their refusal of it was unreasonable. So we look at the role first of all, we compare it to their old role, and we have to decide whether or not it was suitable alternative employment. Joan's touched upon sort of that already. But then secondly, we have to look at their refusal of it, and we have to decide whether or not their refusal of it was reasonable or not. And if it was unreasonable, then we're in a situation where we say, well, notwithstanding the fact that your employment is terminating by reason of redundancy, you're not entitled to a statutory redundancy payment. And that can be quite tricky, particularly when you're looking at the reason for refusal. So you've really got to get to grips with why the individual says this isn't for me, and do we think that that is a reasonable or an unreasonable answer. So if they say, look, I've tried it out, but actually my childcare commitments, I just can't get them to fit in with the working pattern that goes with the role, and I know that that can't be flexed at all, then you're more likely to say, yes, okay, that seems like a reasonable answer, as compared to, no, I just don't like it, with nothing more being given to you. If we then go along to the next column, so again, we've got an employee deciding that the alternative employment is not for them. Again, they're treated as having been dismissed for redundancy when their old job ended. But here they will be entitled to their statutory redundancy payment, their SRP, if it was unsuitable employment, or rather, if it was alternative employment, but not suitable alternative employment, which again comes back to Joan's Venn diagram, or if their refusal was reasonable. In that situation, still redundancy, and still they get their statutory redundancy payment. Last column, if during the trial period we decide as the employer, no, this isn't working out, we thought you were going to be a good fit for this role, but actually it's too big a stretch or something's not working, we've made the wrong decision on that, then we're terminating in those circumstances, but the reason for the termination is connected to their change in role. So in that situation, we've still got a dismissal by reason of redundancy when the old job ended and the employee still gets their statutory redundancy payment. If the reason for dismissal during the trial period by the employer, though, is completely unconnected to the change in role, so if we have a situation, for example, where there's gross misconduct during the trial period and we dismiss for that, nothing to do with the redundancy, nothing to do with the change in trial, the trial period and the change in role, then there we're looking at a termination date of the actual date of dismissal and no statutory redundancy payment. So as I said, hopefully that helps to sort of help you work through what happens in a statutory trial period situation. The one additional red flag, I think, is what does all of this mean in circumstances where you're a business that offers enhanced redundancy terms? Because this is very much about the statutory trial period and the statutory redundancy entitlement. So make sure if you offer enhanced redundancy terms and they are documented somewhere, that you, as a takeaway from this session, just double check what you say about what will happen in circumstances where an individual unreasonably refuses a role of suitable alternative employment, because what you would not want to have in that situation is an individual saying, but I'm still entitled to my redundancy payment because per the second column, my employment is still terminating by reason of redundancy, and it doesn't say anywhere that I don't get my enhanced redundancy payment if the role was suitable alternative employment and my refusal of it was unreasonable. So that's that hotspot. Next, we're coming on to dealing with illness absences. And I think the first point just to remember here is that we mustn't forget about people who are out of the business when we're doing redundancy exercises. And that will be obvious to you all, and you will know that, but it's just a reminder on that. Particularly people on sick leave, but you'll have people who are on family-friendly leave. You might have people who are on secondment. So just making sure that when we're sitting down and thinking about our exercise, we've identified everybody who's going to be potentially impacted by it. But for people who are absent from the business as a result of illness in particular, we're going to have to think about how do we best notify them that they're at risk of redundancy or that there's going to be a redundancy exercise, and how do we also engage in consultation with them. For people who are long-term sick, you might already have agreed communication plans or strategies in place with them where you say HR will contact you once a month just to check in, or you should contact your line manager, and that's all been agreed, in which case we want to make sure that we know that and that we're not going in and doing something that then is counter to what we've already agreed with the individual. Similarly, we'll be thinking about, well, why is the individual off? Somebody who is recovering from a broken leg and who can't therefore be on the shop floor is quite different to a situation where somebody is very poorly and undergoing intensive treatment, and how we would handle those two different situations or handle those situations would be different too. Not everybody who's off ill will be disabled, of course, but we need to make sure that we've turned our minds to that. Have we thought about our individuals who are absent as a result of illness actually or potentially disabled under the Equality Act? Because if they are disabled under the Equality Act, we may well have a duty to consider reasonable adjustments in respect of them. And the duty to make reasonable adjustments arises in circumstances where we have a disabled employee who is at a substantial disadvantage as compared to non-disabled persons. And we have a duty to try and remove that substantial disadvantage. That's what we're trying to do there. So we're trying to sort of level the playing field for them. So we might in this situation be thinking about the process for selecting employees, the selection criteria that we're applying. Do we need to make any adjustments in respect of that if we think that what we're doing is going to put a disabled employee at a substantial disadvantage? We might be thinking about the process for selecting candidates for alternative employment. So if we're, for example, almost treating it like it's an interview process, what would we do for a candidate who was brand new to our organisation in terms of reasonable adjustments if they had that particular disability? And what should we be doing for our existing employee who is disabled in the context of them applying for alternative roles within the business? And then the role itself. What adjustments might we have to make in relation to the role itself in order that the individual can perform that role going forward? So not forgetting about that. I've put a red flag beside the last bullet point, which I know is ironic because this is all red flag, but this is an extra special red flag, which is thinking about individuals who are long-term sick employees who are entitled to benefit under a permanent health insurance scheme. And the red flag here is really because it has been established for a long time in case law that an individual who has an entitlement to permanent health insurance has an implied term in their contract of employment that they will not be dismissed, thereby denying them the benefit of that PHI cover. And therefore, an employer who dismisses in any event is in breach of contract, breach of that implied term, and their remedy is a damages claim that pays out the entire amount that they would have received under the PHI scheme. And given some PHI schemes, although not as common now, but some will pay out until retirement, it's potentially a very significant sum of money. Now, the case law has been moving on, and we have now, it's established that you could dismiss in a gross misconduct situation. There is also a case that says that you can dismiss in a redundancy situation, but it's not you can just go ahead and do it. What we're saying is you must pause for thought if you identify a situation where you have an individual on PHI or who is entitled to receive PHI, who is then also identified as being at risk of redundancy. And the documents that you'll want to gather are the individual's contract of employment to check what you say in the contract about the right to dismiss as compared to the entitlement to a benefit under a PHI scheme, and also the rules of your PHI scheme. If you've got a comp and ben team within your organisation, you'll also want to bring them in because they will have a view as to how this should be handled, and you'll want to speak to your insurer. So there'll be a bit of homework to be done in relation to those individuals if that's what you come across within your exercise before you then go ahead and actually make the decision to terminate employment on grounds of redundancy. And then the last hotspot that we're going to look at today is suitable alternative employment and family leave. So you will all be aware, because for some time women have had a particular statutory protection if they're on maternity leave during a redundancy process. So the first thing that we're just flagging is to remember that employees on adoption leave and shared parental leave now have the same protection. So it goes to a wider group of people. Now, the protection is not that they can't be included within a pool. The protection is not that they can't be identified as being at risk of redundancy. It is only that they must be offered alternative employment where there is a suitable alternative vacancy, even if there are others who are also at risk of redundancy. And it sort of recognises that individuals who are out of your business on maternity, adoption or shared parental leave are at a disadvantage when it comes to trying to find alternative employment because they're not in the business at that point. And it therefore tries to remove that disadvantage by saying that they should be given any suitable available vacancy over any other individuals who are also at risk of redundancy. It's important to note that as things currently stand, the right or their protection is only engaged when the employee is on leave. But there are proposals that will be extended to include a period after the leave has ended. We're not quite there yet. And Joan and I were talking about this earlier in terms of a trend that we've seen whereby employers are almost trying to time their redundancy exercises so that leave, that protection rather, isn't engaged, so that the individual who's absent from leave comes back, and then on day 2 there's an announcement that there's going to be redundancies within the organisation, so that the employer doesn't have to engage with whether or not that protection applies and how they would deal with it in practice. That is a tricky course of action to take, not least because what we're seeing is that following GDPR, employees are much more aware of their rights to request their personal data. We're seeing far more data subject access requests than we've ever seen. And so an employee who thinks, that's a bit funny, day 2 after I come back from my period of shared parental leave, I'm now being told there's a redundancy exercise, I might just put in a data subject access request, get my personal data, see what's been going on. And remember that documents that are being created about redundancy exercises, and in particular about individuals, would have to be provided in the context of that, unless one of the exemptions applies. So it is a risky strategy, and not one that we would be advising employers to take, not least because if you get this wrong, your dismissal will be automatically unfair, and there's also the risk of discrimination claims too. So potential exposure for the business if you get it wrong. tricky issues within this hotspot, as if it's not tricky enough. What if more than one person is on maternity, adoption, or shared parental leave? So there's no ranking. It's not that one beats the other or one is more important than the other, or is given priority over the other. So in that sort of situation, you would have to agree a fair selection process within the pool of people who have the special protection in order to identify who gets the vacancy. Because, as I said, the protection is to be given a vacancy. It is not to go and create jobs for these people. It's just if there is a vacancy, and it has to be a suitable one. And then finally, this issue can become much more difficult if there is a role redesign type exercises, as Joan was talking about, or a diminished pool and a role redesign together. Because are you truly creating new jobs, or are you just cutting jobs? And we've seen quite a lot of cases on that, actually, where the employer approaches it in a particular way and says, well, no, there weren't any vacancies, but actually what the individual says was, well, no, that job was different and therefore it was a vacancy, and so I should have been given it. And you then end up into analysis as to whether it was a new job or whether it wasn't. So that is all we were going to say on suitable alternative employment and family leave, which was our last hotspot, and leaves us some time for some questions.
Absolutely. I think there's one which that whole question, Fiona, of trial periods, suitable alternative employment matching is obviously hitting a nerve, because we've got one question here about it says, what if we have an employee who's not been placed at risk, who we've mapped into a role and can demonstrate it's a match, but the employee doesn't agree it's a match and wants to leave the business? Well, then there's kind of about 10 layers to that question, because you're starting off by saying you don't have a redundancy process going on at all. So really, you have to be very secure in that situation that the job that you're asking them to move into is something they could be asked to do within their existing contract. So in other words, you do not have a redundancy situation there. And if that's the case, then it's a resignation. If you're in slightly grayer territory where you start to move into the question of whether or not this is something that's different, and you do have a diminished requirement to have employees carry out work of a particular kind, then your alarm bells start to be ringing about whether or not you need to give them some kind of trial, and explore more carefully the whole question of whether or not that is a true match. Can you extend the trial period, as 4 weeks is quite short? Well, that's a good point, actually. Yes, you can. Of course, you can try to extend the trial period as long as you like. I think, I suspect that within the statutory regime, and Fiona will know this, there might not be the flexibility to do that. Is there? You could, if you agree it outside of that, I'm sure you could, but.
So within the statutory regime, you can extend it in particular circumstances, right. But if it's an extension for a reason outside those circumstances, then you're taking it out with the statutory regime.
Right, okay. I know that it's quite common where people have got sort of reasonably sophisticated agreed procedures and policies for redundancy, particularly where there's an enhanced redundancy right. You see quite a lot of regulation around trial periods and their use, and that goes back to the fact the unions used to have a real bee in their bonnet about trial periods, less so now, but it used to be a big deal, and particularly when it came to treating it as a gateway to redundancy pay that people wanted but felt that they were being denied access to because they were being shoehorned into a job that they didn't want, and that used to be a sort of fight territory. But yeah, I can't say that I come across it very often, where people make the argument, usually because there's a kind of a conflation of the debate about whether it's suitable alternative employment and the trial period itself. It's relatively unusual for people to say, okay, I'll give it a go, but I want to preserve my rights meantime. But it's perfectly possible to extend it. Next one, when can you advertise a vacancy externally? Can we say we'll do it when this is where the role is very specialist, we need to recruit a leader? Yeah, I worry about that term, leader in the field. It's going to immediately terribly subjective. I have to say, this is an area where you should take advice, because there's a couple of cases on this, neither of which are particularly helpful because they fall on their own facts, heavily on their own facts. We tend to say, if you can, you do a proper assessment, you ring fence the people who are surplus, you put them in the ring first. And if you're really then looking to be able to demonstrate that they really cannot do the job in the way that you need it done. Now, if that means that you've got somebody, for instance, who has really no leadership experience at all, and the new job has got some sort of leadership element to it, you just need to be able to justify it. You need to be able to demonstrate that really clearly. But I can see the scope for somebody arguing that nebulous things like fit, leadership potential, etc., being a tricky thing to screen someone out of a job when they have the basic skills to do it. And I don't get me wrong, we are fully aware that you often redesign jobs, not just the content of the job itself, but the attributes that you want the employees to have when they're doing the job. So yeah, it's not a straightforward one. I'm afraid I'm going to give you a take advice on the specifics answer to that particular question. There's lots more questions, I'm afraid, but we are out of time. Yeah. If you've left your name, we'll answer. If not, we won't be able to answer, but please don't hesitate to get in touch with us. And thank you very much for attending. We will circulate slides and we look forward to engaging with you in the future on what is, I'm afraid, a sad subject, but obviously one we know you're all dealing with on a day-to-day basis. So best of luck.